I'm Emily Preifogel, an assistant professor of law here at the University of Michigan Law School. And on behalf of Michigan Law, I'd like to welcome you to the third and final lunch in our three-part series, Race and Property in Historical Perspective. The series has sought to bring together scholars whose historical research is on the cutting edge of race and the law scholarship. Today, I am delighted to introduce you to Professor Taja-Nia Henderson and Professor Jamila Jefferson-Jones. Taja-Nia Henderson is Dean of Rutgers Graduate School and is a professor of law. Her scholarship focuses on the historical impact of punishment regimes on property systems in the United States. Her work has focused on the legal history of incarceration and chattel slavery. Her JD and PhD are both from New York University, where she was a Dean Scholar and the recipient of the Gary E. Moncrief Graduation Award. After law school, she clerked on the U.S. District Court for the Central District of California and practiced commercial litigation and pro bono civil rights law for Arnold and Porter in New York. She has held prestigious fellowships at the Library of Congress and the New York Public Library. Professor Henderson was also a J. Willard Hurst Fellow in Legal History and is a member of the Steering Committee for Newark Reentry Legal Services. Her work has also appeared in equally prestigious journals, including the NYU Law Review, the Stanford Journal of Civil Rights and Civil Liberties, and the Law and History Review. Let me also introduce you to Professor Jefferson-Jones, who is an associate professor of law at the University of Missouri, Kansas City. There, she teaches property, real estate law, and professional responsibility. Her research focuses on theories of property and ownership, as well as wealth attainment by marginalized groups and communities. Her work has three strands: one that focuses on the interplay between sex, race, status, and property; a second that focuses on the intersection of property and criminal justice; and a third on the regulation of the housing sector. Prior to her teaching career, Professor Jefferson-Jones practiced law in DC and New Orleans, and she was a staff attorney in the New Orleans Public Defender's Office. She is a graduate of Harvard College and Harvard Law School, where she was the executive editor for the Harvard Civil Rights, Civil Liberties Law Review. And her research has appeared in the West Virginia Law Review, American University Law Review, and the Journal of Gender, Race, and Justice, among many others. We are fortunate to have such distinguished guests with us today. Welcome, Professors Henderson and Jefferson-Jones.
Thank you so much. Thank you for having us, Professor Preifogel. We're really excited about being here. And we're excited when you reached out about doing this series. So thank you so much to you and to the University of Michigan for having us.
Absolutely. Thank you, Professor Preifogel. Thank you to the University of Michigan. Thank you to Hannah Patton, who's a student who's helping us out today. It really means a lot that that we will have this opportunity to chat about our work and also to chat in this format, which gives the audience substantial time to really engage with the material and for us to engage with you. So we're really looking forward to it. As Professor Preifogel mentioned, the basis for our talk today is an article that we wrote together, hashtag Living While Black, Blackness is Nuisance. In this work that was published earlier this year in the American University Law Review, we worked to bridge the gap between criminal law and property law by examining how complainants in what we call living while Black incidents deploy the language of land use to provoke state violence with the express aim of excluding Black people from shared spaces. While the popular narrative about these incidents is justifiably influenced by concerns about criminal justice policy and high-profile police shootings of unarmed civilians, another element to the living while Black phenomenon caught our attention, namely the 911 callers who were requesting police intervention to remove or detain the Black targets of such claims were not merely relying upon criminal law concepts to articulate their claims of imminent harm. These callers were also using property law concepts, particularly the language of nuisance and trespass, to invoke the intervention and assistance of law enforcement. We see this phenomenon as being firmly grounded in property and its racialization, an insight that we explore in our article and that we'll talk a little bit about today. This brings us to the phenomenon of living while Black. The term expressly refers to the lived experiences of Black people in the US who have been targeted by their neighbors for police complaints over innocuous behavior. And in each of the instances that we catalog in our piece, we see at work a particular strand of racist hostility and aggression, one that we think has deep roots in American society.
So, what is living while Black? In 2018 alone, one CNN report noted that police had been called on Black people, on African Americans, for the following: operating a lemonade store, golfing too slowly, waiting for a friend at Starbucks, barbecuing at a park, working out at a gym, campaigning door to door, moving into an apartment, mowing the wrong lawn, shopping for prom clothes, napping in a university common room, asking for directions, not waving while leaving an Airbnb, redeeming a coupon, selling bottled water on a sidewalk, eating lunch on a college campus, riding in a car with a white grandmother, babysitting two white children, wearing a backpack that brushed against a woman, working as a home inspector, working as a firefighter, helping a homeless man, delivering newspapers, swimming in a pool, shopping while pregnant, driving with leaves on a car, trying to cash a paycheck. So driving while Black, walking while Black, swimming while Black, studying while Black, hanging out in a cafe, Starbucks while Black, all of these things, and having the police called to remove you from these spaces for merely existing. That is living while Black. These phenomenon, by modest estimates, this term living while Black has been used on social media to describe these experiences hundreds of thousands, if not millions of times. Since 2018, we've been researching this phenomenon and seeking answers to the following question: whose rights and which of those rights ought the law and law enforcement seek to protect? And what remedies ought to be available to those whose rights are violated?
So this will be familiar to many of you. In April 2018, a Starbucks manager in Philadelphia telephoned 911 to report that two men had entered the store and were not buying anything. At first glance, the call seemed to be a run-of-the-mill private trespass variety, whereby a commercial establishment may seek police assistance to remove persons thought to be either disruptive or violent. In this case, however, neither condition was present. The two men who were targeted by this manager had entered the store less than 2 minutes before she called police. Videos show that the men sat at a table, as people sometimes do when they enter a busy Starbucks, and began chatting together. Less than 2 minutes later, the police were called. When police arrived, the two men were arrested for criminal trespass. Videos of their arrest, with the men being accosted in the store and led out of the store in handcuffs, circulated on social media, sparking massive public calls for a boycott of Starbucks due to the perceived racist actions of this particular store manager. Starbucks responded to the growing public pressure by closing all of its stores in late May of 2018 for a day-long training opportunity. This Starbucks incident, of course, at the time was just that. It was an incident. It was an anecdote, if you will. It wasn't until I think that Starbucks incident sparked massive public outrage that Jamila was actually first inspired to pursue this as a research project. And in the interest of full disclosure, we were together attending a conference in June of 2018, and Jamila approached me at a conference room table and asked me what I thought was happening in these conflicts. I told her at the time I didn't know. And she proffered that she thought that these 911 calls were all about nuisance and that there might be something there. Of course, it's not every day that somebody comes to you with such a flash of clarity on a project. And as soon as she said it, I said, I want in, let's do this together. And that's how we got started. So over the summer and the fall of that same year, Regrettably, there were dozens of these incidents, all with accompanying video witnessing. And in this torrent of incidents, we began to see a pattern. This powerful combination of high quality cell phone video and social media brought to light a barrage of incidents involving 911 calls reporting that Black people were occupying space that the callers believed that they ought not occupy. And in nearly all of these cases, the targeted men, women, and children were in fact in places they had a legal right to be in and engaging in activities in which they had a legal right to engage. Widely circulated and debated on social media, these incidents all went viral, spawning a series of social media hashtags, most strikingly, hashtag living while Black.
The social media hashtag living while Black is a play on an older term, driving while Black, which euphemistically describes the violence of police racial profiling of Black drivers. Living While Black first appeared as a social media hashtag to mobilize attention to incidents, as we just noted, where white people call the police on Black people for engaging in non-criminal everyday activities. While the term living while Black had been previously used to describe the fraught conditions of navigating racist encounters for Black people, the hashtag, via these high quality cell phone videos and the use of social media, brought the term into the nation's common lexicon. Living while Black incidents are not new. They harken back to Jim Crow America and the notion that Black people should be restricted to subordinate places, both in the social hierarchy and in spatial hierarchies. But there are some commonalities between now and then, namely that law and its enforcers are being used to draw lines of racist exclusion. What's different is that cell phone technology has put high quality video production and distribution in the hands of the masses. Everyone is able to use this ostensibly objective medium to validate their witness to abuses, whether to the circumstances prompting false 911 calls or to police violence. The ubiquity of cell phones does not make it easier, does make it easier for racists to call the police quickly, right? But we also think this is outweighed by the benefit that victims and bystanders are able to reap. Cell phone video corroborates what had previously been dismissed as unreliable and anecdotal. What's not different from the Jim Crow era or earlier eras is the policing of Black people within public spaces. So this is not different. And the use of law enforcement as a tool of racist exclusion. Those are the things that are still a part of what we've seen as this older idea that Black people ought to be in place.
So what does it mean for space to be racialized? Property is racialized when it gets ascribed a racial identity or character that includes some and excludes others on the basis of race. Those spaces can be neighborhoods, parks, sidewalks, avenues, boulevards, among other spaces. Spaces get racialized by the people who use and lay claim to them, irrespective of whether those spaces are in fact legally designated as public or private. The central principle of what my colleague Elise Body calls racial territoriality is that what should be shared space is being wrongfully claimed in the name of racist exclusion and in the interest of white supremacy. And of course, as Professor Jefferson-Jones just mentioned, while the social media and public conversation phenomenon that we've been examining emerged only in the past 2 years, racial territoriality itself is not new. These ideas date from Jim Crow and the hardening of racial lines in our society. Not surprisingly, emancipation, as noted by scholars including W.E.B. Du Bois more than 100 years ago, did not lead to freedom. Although the moniker is not new, we know that such encounters between and among Black and non-Black neighbors have long been the subject of civil litigation. Commencing in the years following Reconstruction, white litigants began pursuing property law claims in courts throughout the country, sounding in nuisance in an attempt to police and arrest Black proximity. We see in the earliest of these an effort by white litigants to cast Black people and their nearness as property harms deserving of legal protection. And what we see, interestingly enough, when we talk about this in the piece, is that in each of these cases, each of the cases that we have been able to identify, even while the courts themselves and the judges themselves frequently accepted as valid the social undesirability of Black proximity, that presumptive undesirability did not always result in the granting of a remedy. So even as these Jim Crow judges explicitly admitted their own racist beliefs and struggled to reconcile their personal preferences with the ostensibly neutral, race neutral common law of nuisance, in decision after decision, we see judges rejecting claims for property relief based on race. For example, in 1882, James Falloon, an attorney in Hiawatha, Kansas, brought suit against his neighbor, Adam Schilling, claiming that Schilling's construction of tenement houses along a lot line that was shared by the two neighbors was a nuisance, not because of how the tenements were to be built, not because of any conditions in the tenement, but because the tenants in the tenement were Black. In a clear nod to a social construction of whiteness, Falloon included in his pleadings that he and his family, quote, did in no manner associate themselves with colored people, he and his family being white people, unquote. According to the court, the allegation that Schilling leased the tenements to persons that the plaintiff had termed, quote, worthless Negroes, unquote, was unavailing in this nuisance action for two primary reasons. First, because as the court uncritically noted, the tenants included a minister and his family, who the court noted were not in fact, quote, worthless Negroes, unquote. Second, the court noted, a Negro family, and this is a quote, a Negro family is not per se a nuisance. As long as that neighbor's family is well behaved, it matters not what the color, race, or habits may be, or how offensive personally or socially it may be to plaintiff. Plaintiff has no cause of complaint in the courts. In Hall v. Moffitt, another case, petitioners sought to enjoin the use of land as a Black private cemetery, alleging that a Black cemetery would cause irreparable harm. This is from the pleadings. The injury and damage to petitioners' property and their sense of pride in their community will be irreparable and cannot be compensated in any kind of action in a court of law. Rejecting the plaintiff's claim that the area's Black population already had a segregated public cemetery available for its use, the court noted that the fact of a pre-existing public cemetery for Black interrees did not permanently preempt the development of successive parcels for the same purpose. In a clumsy attempt at humor, the court noted in dicta, quote, we can see no reason why even a Negro should not prefer to rest after death from both hunger and hardship, unquote. On its own, in both of these cases, we see that the mere presence or proximity of Black people, whether living or dead, even if undesirable or inconvenient for whites, did not give rise to actionable nuisance claims.
We saw here an opportunity, and it was an opportunity to explore why this kept happening. So we can go back to the 1800s and see it happening, and we see it going forward into present day. We wanted to understand the motivation of these hashtag Living While Black 911 callers, our antagonists. It was important for us to consider both current motivations that may be driving this phenomenon and, if possible, historical and structural conditions that may be at work here. In the fall of 2018, the archive for our project was being created, in the summer and fall, it was being created on a weekly and in some cases daily basis. This archive of video recordings, 911 calls, still images, and social media content and references gave us a mountain of material to work through. In our minds, what we were seeing lent itself to a phenomenological research approach, right? So that was our approach. And this approach centered the experiences of the individuals and forced us to suspend our own biases and preconceived notions about what may be prompting certain behaviors. So for us, this means that we would not assume the motivations of our antagonists. Instead, uh, instead we would use our own words, or their own words, I'm sorry. So we're not making assumptions. We're using their words and their language to suggest what may be motivating them. Thankfully for us, we had a treasure trove of 911 recordings and transcripts, and that allowed us to develop and delve into several of these incidents to really see what was going on, again, in the words of the callers themselves.
So, with the exception of the Starbucks incident, perhaps the most notorious Living While Black incident of 2018 occurred in Oakland, California, along the shores of that city's Lake Merritt. We see in both the April incident at Lake Merritt and subsequent incidents, either in California or across the country, the leveraging specifically by white women of racist tropes around Black predation and violence and white female vulnerability. In these cases, we see in the 911 transcripts, these women using the mechanism of 911 emergency services to craft narratives of both victimhood and heroism in the face of threats to an imagined public. And in the case of the Oakland incident, this was the woman is Jennifer Schulte. In Ms. Schulte's case, she was a hero in her own mind against wayward barbecue coals that might threaten the health and safety of children. This imagined public that these women claim heroism over, though, is one that is totally exclusive and does not include Black men, Black women, or Black children. When initially confronted about her choice to call the police to report the Merritt Park barbecuers, Jennifer Schulte displayed steadfastness in the face of her critics, refusing to yield or end her call to 911. Seconds later, once connected with the 911 dispatcher, though, Schulte began to cry and claimed to have been harassed. And once the dispatch police officers arrived on the scene, Schulte began to cry so much so that she was initially unable to communicate with the officers at the scene to explain to them what had happened. Now, this is after having aggressively and also, it is important to note, unilaterally initiate a confrontation with these barbecuers, and after threatening the barbecuers with the language, "Y'all are going to jail." It was only when Schulte had the attention of the police and emergency personnel that she, in fact, claimed to be a victim of others' aggression. And in so doing, she strategically tapped into a long history in this country of white fears of Black male predators. Variations on this duo of discursive strategies recur in several of the Living While Black incidents that we catalog in our research. These tropes are obviously antithetical to integration and together work to support the establishment or maintenance of exclusively white spaces, in these cases, under the clear protection of public law enforcement.
On May 25th of this year, Amy Cooper called 911 on Christian Cooper, a Black bird watcher in New York City's Central Park. She did so when he admonished her about violating the park's dog leash rules. Rather than simply comply with the rule or take her dog to an unrestricted area, she called 911 and deployed racist ideas about Black men to communicate to the dispatcher that Mr. Cooper was a threat. In fact, before she called 911, she told Mr. Cooper that she was going to leverage a racist trope to summon police, making sure that she emphasized that an African American man was threatening her and her dog. Her intention was to signal to the dispatcher that Christian Cooper's race alone made him a threat worthy of swift police response. It has recently come to light that Amy Cooper had a second previously unreported conversation with a 911 dispatcher in which she falsely claimed that Christian Cooper tried to assault her, thus ratcheting up her claim of Black male violence and further endangering Christian Cooper's life. On that same day, May 25th, 2020, that same day that Amy Cooper in New York wielded white womanhood and white tears and threatened Christian Cooper's life with her ability to call forth state violence, George Floyd was being murdered in Minneapolis. His death recorded, and it was an example of state violence exacting the ultimate price from Black bodies when called upon, even for minor criminal enforcement. If George Floyd could be executed for allegedly passing a counterfeit bill, then Christian Cooper could end up dead for having asserted himself in a space claimed by whiteness.
In the specific arena of racially motivated 911 calls, some jurisdictions are in the midst of shifting the burden of justice from the victim to the perpetrator. Some cities and states have enacted laws that seek to actually punish perpetrators of living while Black abuses. So last year, the city of Grand Rapids, Michigan, for example, passed a human rights ordinance that prohibits crime reporting based, among other things, on an individual's actual or perceived color or race. Such biased crime reporting may now result in prosecution for a municipal civil infraction and is punishable by a modest fine in addition to cost, damages, and expenses. Also last year, the state of Oregon enacted legislation that allows the targets of living while Black calls to sue those who initiate such calls for civil damages up to $250. And in the wake of the Christian Cooper, Amy Cooper incident in Central Park, a bill that had been introduced 2 years ago in New York State has gained new life. It was already illegal in New York to make a false 911 call, but now in the wake of the Central Park incident this year, it is now a crime, a hate crime, to call 911 and make a false accusation of criminal activity where that false accusation is based on race, gender, or religion. This is now the law in the state of New York. In addition to statutory remedies, there have also been numerous calls to better train 911 dispatchers so that they can ask questions that are better aimed at rooting out bias rather than unquestioningly sending officers to the scene. This, for us, is a public safety crisis that demands more attention. Finally, we also there have also been calls that police must be better trained to respond to instances that may be living while Black instances. For example, a call that was made to police in Brooklyn earlier this week that there were thousands of Black people convening in lines in the Flatbush area of the borough. Those people convening in lines were there to vote. The police received a phone call that said there are thousands of Black people convening in the neighborhood. So with better training for police, you can better support and protect officers' lives and also better protect the victims of any false reporting where it may exist.
So that leads us to this question. What is justice and what is the role of the law and law enforcement in this context? And so that's an open question that we want to leave everyone with, and maybe can kick off our discussion in that way. Again, all that we've been talking to you about is from our article published earlier this year, hashtag Living While Black, Blackness as Nuisance, and you can find it in the American University Law Review.
I'm conscious of time here, and I know I have a lot of students on the call today, so I want to switch and ask you a question on behalf of the students. I think they would very much appreciate what advice you have for them as scholars of race in the law for how they might engage in their own research in race in the law, but also what to do when they're in a doctrinal law school classroom that seems disconnected from the types of issues that you guys are talking about to us today.
I'd like to start with that one. Two things. The first is, as we mentioned before, that you really can't, when engaging in research, it's really important not to go in with any preconceived ideas, because if you had told me that we would find what we found in the historical record, I wouldn't have believed you. And we start with 1838, so 1830s, and going all the way to the present. The courts were steadfast, even when they said, well, we don't like Black people either, but this is not a nuisance. They're just living does not constitute nuisance. So that was something that was surprising, and I really don't think that either one of us expected to find that. Then with regard to being in class, I think that if you're in a position where your professor isn't keyed into these issues, and that you need to be the one who does this, and it's not necessarily fair, and it might not be comfortable, and you may need to find other allies within your class. Oftentimes I've seen it. As a professor, I get to see which of my students are going to work together on certain issues, what their issues are, who's going to speak to certain things. And that'll give you the motivation to go out there and find that outside information and bring it back into the class, bringing credible resources to the conversation. Things that maybe they can refute, but they can dispute, but they cannot refute as being a credible source. I, in my classes, do try to bring those in and try to give my students more information. I bring in all sorts of law review articles and critical resources that show them that what you're reading in the case isn't always all that's happening. I give them historical context, and I give them other resources that have delved into what was really happening in the background. I always make them center themselves in the date, because oftentimes the students get past the date and just want to start reading. I'm like, what year was this? What was happening in our country in this year? Now think about that in the context of the way that the court came out on this particular issue. And a lot of times students just miss that. But I think that it's important, when you don't have a professor who's keyed into these issues of race and equity in every course, because it really does run through every course, that you and some of your fellow students have to get together and bring in those resources if you're interested.
I could not agree with that more. I encourage students to take your legal education by the horns and make it yours. And that means take the classes that you want to take. That means read the material, whether it's assigned or not, that you want to read. And that means ask the questions that you want answers to. And it absolutely, Professor Jefferson-Jones is right. It may feel alienating, and it may feel that professors aren't so welcoming to having new material and new content being introduced into class. But I don't think we can afford to not do it, because law school is dehumanizing enough without me also now losing the ability to ask questions that are keeping me up at night. If I can't put that to my faculty, then this may not be the place for me. And I don't mean that law school shouldn't be the place for me. Maybe an institution may not be the place for me. So I encourage students to ask questions. I encourage students to read outside material. I encourage students to ask their classmates, what's the evidence for that? This is something that I drill in all my classes. This helps students to test assumptions, and also helps them to be more reflective about their own experiences and how those experiences are extrapolative. Sort of, what is the evidence for that? Or is your experience the only evidence that we have for this? Can you bring something else to the table? How can you be persuasive? And I think of this as really an exercise in legal advocacy. You will sometimes be on the unpopular side. How do you marshal all the evidence at your disposal to convince everybody in the room that this should go your way? Law school, I think, can be treated exactly the same. In the classroom, what do you bring to support your arguments? And I will also say that property, to me, is rich for this, because I like to tell my students everything begins with property. All those other classes are secondary to property in the first year.
Absolutely.
And the other professors are like, don't say that, it's not true. It's totally true. Trust me. Property is central, because property is where the state sort of decides who gets to have and who gets to not have and who gets to go hungry. And if you don't see that as central to everything else that we do, there is no relief in a contract case if there is no property to be claimed. So I try to get students to really be thinking about power, and to take the conversations that we have in contracts about the state authority, state power, take those conversations and paradigms into their other classes and ask questions about power in torts, in contracts, in tax. Ask these hard questions and help everybody, not just you, but help your peers, help your colleagues to sort of come to different understandings by using different paradigms.
And that really goes back to the question that you asked earlier, Professor Preifogel. It was the question of the interplay between property and criminal law, property law and criminal law. Well, if we have property rights, then they must be enforced. The state must recognize them, and the state must have an enforcement mechanism. And that's where the criminal law comes into play. That's where police enforcement comes into play, because the police are often called upon to enforce what are presumed property rights. So that's what nuisance and trespass are about. And that's what's playing out in the scenarios that we depict in our paper.
It is no accident that most people are incarcerated right now for either nonviolent drug crimes or for property crimes. That is not accidental. That is because law enforcement is overly committed, overly concerned about property protection and preservation. And you can see this summer, we have seen police resources, law enforcement resources be committed in city after city to protecting property at the expense of lives and limbs.